Good evening, chat. Hello. Ooh, okay. Hold on. There we go. That was weird. Couldn't hear myself for a second. You guys are like, what do you mean? I do the feedback into my ears. It's a great way to know that this is on, because when it's not on, I don't hear anything. So I've gotten used to it. At first, it threw me off. 2.0 showed me how to do it. And now it's just like a normal thing. So it all works out. But welcome to the show, guys. It is Wednesday night. God, it's Wednesday. Yes, it's Wednesday, October 1st. You know, wake up, wake up, wake up. It's the first of the month. Yes, also as 2.0. I've never heard this before, but you say rabbit on the first of the month. I've never heard that, but apparently that's a great way to do good luck. I'm not sure. KJ says so many privates are missing their car payments now. Yes. All those Hellcats on like 42% interest. Oh no. Man, them and their stripper fiancés are going to get really disappointed. So, we are going to... Russell is sharing an episode with someone else. Yeah, because Russell's... The sanctions issues for Russell, it's only 13 pages. I can't do a whole show on him. That's not enough. That's not enough lull for tonight, chat. It's not enough lull tonight. And it's something that we can add on, and it dovetails very good with Stuttering John. And we're going to do it that way. I think he's a good kind of cap to the night here. But we're going to start with Stuttering John, then we'll go into Russell Greer. And if you guys are new, welcome. My name's Sean, someone's potentially criminal. I'm an attorney in the Cleveland, Ohio area. And yeah, we're going through what's going on with Stuttering John. And then 2.0 says, it's supposed to be the first thing you say on the first of the month, that it brings luck all month long. Yes, the first thing she usually does say is Clyde, yells at Clyde to move, and then rabbit. It still works. Interesting, says Bonbon, please. I'll grab her in a second. So she's wandering around, so in a minute. But yes, it is October already. It's so crazy time. So should have named Clyde Rabbit. It's actually not a bad idea. 60 more days and Trump could fire the furloughs. Does he have the endurance, chat? I think he does. And they'll get fired right after Thanksgiving. It'll be perfect. They'll be fired after Thanksgiving and right before Christmas. Yes! More! Does Bonbon sleep in the bathroom? No, we're not shitty people and shitty human beings. Bonbon sleeps in the normal part of the house. Actually, Bonbon, we take her little dog bed, we put it on the bed, and she comes up and sleeps in it. Because I'm not a horrible fucking human being. When do we vote on my Halloween costume? Some point. Yeah, I wouldn't know it was October from the temperature day. Yeah, it was like 70. It was like 75 degrees but it was that nice kind of where fall's creeping in, and there was kind of the breeze a little bit and a little bit of chill in the air. So it wasn't a horrible or obnoxious 75 to 80. It was pretty good. Yes, it was bed on a bed. 100% it was. Dressed like PPP. Well, I'm not going to wear the curb your anti-Semitism hat. I mean, that ain't going to fly. That ain't going to fly on this channel. We can't do that. Your dress is the Hindenburg. Yeah, there we go. I'm going to give people a couple minutes to get in here. For some reason, I set this up and the live never... it didn't work. So I was a little disappointed when I set up StreamYard earlier today. And I come in at 7:45 and I'm like, fuck, it didn't work. So now I'm scrambling to put it together. So I'm sure a lot of people aren't here right now. At least that's what I'm going to tell myself. I can be a pumpkin. PPP was a pumpkin. Yeah, I know, but I'm not doing that. PPP's been a lot of things, and I'm not gonna. Oh, I got something in my teeth. PPP's been a lot of things that just have body paint. I'm not doing. We're not doing body painting. Haven King says, could theoretically a mime lawyer do trials around illegal problems? I mean, technically, you could do it in. Although for mimes, if they just do mime stuff, does it count, or can mimes do ASL? American Sign Language as they're going along, because I guess you could do it if you were a mute attorney or a deaf attorney. It'd be really fucking hard, though. It'd be really fucking hard to do, but I mean, I think you could. I guess. But no, just being a mime and you go, first word, and then... No, it wouldn't work that way, but I guess that would be really weird. But yeah, you could try. We could try. Has Kenoing started yet? I don't think so. Friday. Yeah, I think it starts Friday. Roscoe says, I mean, Tarl fixes for Halloween. You're not going to be the great Reverend Dr. Robert L. McKim Sr.? Shame on you. Shame on you. I need to shave and go as PPP. I still, one day here, guys, I am going to shave, and then I'm just going to shave and just ignore you guys until the beard comes back. Be like, what the fuck are you talking about? My beard's still here. I want to do it to 2.0. She's never seen me without a beard. Hold on. Yeah, so like the very, very beginning when we met, I didn't have, it was growing in. But she's never seen me like consistently shaved up. PPP lawyer skin, you're good. Yeah. Are they going to do a costume for every day they stream in October? They try to. I bet they've got a lot of good. They have skits. They do all kinds of things. It's going to be fun. They do a great job at preparing. I will give them credit for that. They are. You may not like them for the A-logging. You may not like the fact they're Canadians and all that. I get it. I especially get the Canadian part. But they are showmen, and they work hard. They work hard. Would you need jurors who could understand ASL? You could probably have somebody like translate at that point. I don't think it would be an issue there. I want to see a deaf mute attorney object to court and go, ah! So could you get Jesse Lee Peterson as a guest? I mean, I guess I could try. He's gonna be like, do you love black people? And I'm like, define love. And Campsite Z is saying, so the reason they haven't released the pictures of the 30-06 rounds is they haven't located the sabos of the Remington accelerator the shooter used. Well, presumably, if he's using the sabos and make like basically as a slap round, his other rounds he was using probably would be similarly situated. The idea he would just shoot one special purpose round and then not have a backup, I don't think that makes sense to me. So I'm not sure where he would have, why that we haven't seen him yet. And also, oh, and I forgot. Yeah, you could still get, I mean, I guess you could. I mean, can you still buy Accelerator new? Or would that have been somebody's outstanding stock they had? So I will say, it wouldn't be a bad way to penetrate armor. Some plates would go through. Do not shave, you look really good. Oh. Spider McGee says, Aaron has a much better shot at being a lawyer than John. He's younger and smarter, and he has no soul. Oh, well... I don't know. Let's not get too carried away here. Kia Pat says, careful, Sean. Had a friend whose dad always had a beard. The one time he shaved, his wife gave him the never do that again. Well, I've seen that, but I've also seen like the videos of like when people shave their beard, like men will shave their beard and their kid starts panicking like as a baby because they don't recognize a person. Oh, hold on. We have a special guest who's all upset now and jealous. He wanted to join us. I don't know. This guy gets shaved all the time. So, hi, Bob Bear. Mwah. And I could hear Bob jumping. Helen Keller was not real. Well, Helen Keller was real. The idea is that, whatever the hell her name is, Anne Sullivan did all the writing for her. So, I'm not total. I'm only not completely TND. I'm only semi-ND. Yes. Am I betting on the Indians tomorrow? You have to, man. You got to bet on the Indians. Got to bet on the Indians. And then when you get let down, you're like, oh, well, it's football season. And then, the Browns are going to let me down. And, oh, well, I'm not really a basketball guy, but hey, the Cavs are on. They're going to let me down. And then I can say, oh, hey, look, it's time for the Indians. And then over the summer, they'll let me down. And then I can say, oh, look, it's Brown season again. You see, it's just a cycle. It's a cycle for people here in Cleveland. It's the factory of sadness, man. It's factory of sadness. Oh my God here. Like Bon jumped straight up. Ugh. I got them both, chat. I got them both. See, this is what you do. Dogs don't live in bathrooms. They're meant to be enjoyed and they're meant to be cherished. But your dog doesn't have to live in a bathroom. And you also don't have to hold it up for proof of life. Anyways, there you go, Bon. There you go. All right, I'm going to have to sit you guys both down because I can't do this right now. And she is like a cat. She won't actually get down on the desk. All right, Clyde, I got to set you down, Bubba. It's okay, Bubba Bear. I love you. When chat's not giving you any support, they don't love you. There's no Clyde coin. They don't care anymore. They want Bon coin. That's all they want, Bubba. Yeah, I know. He's so sad he's looking away. You guys have turned your backs on him. So he turns his back on you. Bon, down. You're going to go down. Here you go. All right. Campsite Z says they don't want the rest of the world to realize that realize that with a plastic sabot, the bullet has no lands or grooves. I mean, you could 3D print sabots, but also if you did a paper patch bullet, you could paper patch a bullet. You'll get the similar issue of you can prevent rifling from engaging on the bullet itself, and it would be in the paper. Like paper patching is a thing as well. But yeah, like you can 3D print sabots. Clyde is still the star. Yes, he is. All right, guys, it's about that time. Not did you get any forensic evidence off of a VMAX either way. Well, yeah, that's what I mean. Like you shoot him with some core locked 168 grain soft point. There ain't fucking nothing there to, forensically evaluate. So, Helen Keller burned her face answering the iron. Yes. Actually, you want a good Helen Keller joke? You know why Helen Keller's dog ran away? You would too if your name was. Let's see here. Jay Wolfstein says hello. Well, hello. Make sure I didn't miss any of the other points here. Clyde coin crashed and was sold. Well, you're a panicking. Don't be a panicking. Stay strong. Iron hand. No shakes here. No shakes in this house. Blade says, gee, Sean, how come you get 2 dogs? Remember, we're watching Bon for somebody. So watching him for like 2 weeks. Let's see here. Yeah, buy the dip too. Buy the dip. Bon coin is on the rise. No, we not accepted here. Not accepted here. So, let's see here. Andrew says, would you even know if she was what? if she was what? Oh, well, Helen Keller's dog. Oh, never mind. You were gonna stop and take a picture of the Carol tonight at time, but you heard a strange yelling, crying that day. Well, you should have still. So it's an open market. No, it's not. No, it's not. This is Somalia. I am Mohammed Farah Adid. I am the warlord of Somalia. I get to control what happens. All right, let's go, guys. It is time to get going here. Guys, remember, we are going to get started on the Stuttering John nonsense. Oh, it's in response to Helen Keller being a zombie. Oh, okay. So, chances Stuttering John passes the LSAT. Has he said he wants to take the LSAT? That's fucking hilarious. I mean, I can only imagine how that would go for him. I mean, to be fair, you can take it intoxicated. I did once. Well, I was partially, we were we were like, oh, we're going to go to the bar. It's like 8:00 at night on a Friday. And we're like, my buddy and I were like, hey, we're going to go get a beer at the bar. And the bar was right across the street from campus. We're like, we could do this. And we're sitting there, we're having a beer. We're having a beer. We finish it up. It's like 8:30. Somebody tells us, hey, man, there's a party like 2 blocks over. Yeah, we'll go hang out with our friends for a little bit. And it's like 10 o'clock. We're like, yeah, we'll walk back in a minute. And then all of a sudden, it's like 1:30 in the morning. And we're like, whoa, we had a lot to drink. And at that point, we're like, well, God, if we go to sleep now, we're in trouble because we're probably not going to wake up. So we just kept it going and just, stayed and played beer ball until like 6 in the morning and walked over to the other side of campus where they were giving it and we took it. Like I was still at that point. I wouldn't have been able to drive a car. I was over the legal limit, and I still, still did all right. Still did all right. How many times did I take it? 3 times. Like I said, the first time I was like, I didn't plan for it, but I ended up getting kind of drunk, and got a 151, and I was still pretty drunk doing it. 151, which is like right in the middle. You can get a 180 or you can get a 120. 151. So, and that's when cocaine comes in handy. Yeah. But I took it 3 separate times. But no, if Stuttering John's taking it, that would be fucking retarded. Which fraternity in law school? There aren't really law fraternities. There's like honors groups and shit like that. But they have to they tell you you're getting into those, or you have things like the Order of the Quaff. I would never get into that with my grades. So no, I was in a fraternity as an undergrad, but no, none of that shit in law school. Was a drunk one my highest score? No. No. Sarah says, my husband missed his master electrician test by 1 point the first time he took it. Well, that's a bummer. I know a guy who failed the West Virginia bar exam by 1 point. And that's because they regraded it and he failed. So it was like, ooh. So let's see. What are you guys talking about here? Yeah, so we're gonna talk about Stuttering John for real and how weird shit's getting in his case. Now, if you guys have not remember, he's suing for a bunch of things that they're using his name, image, and likeness to profit. That Shuli and Karl from WATP and Shuli from the Shuli Network are doing this, and it's unfair to Stuttering John, and he's very upset about it. Well, this is the interesting thing here, guys. This is from the New York State Unified Court System, which I don't normally like unified court systems, but at least this part for New York is actually pretty cool. And this gives you the case, and it runs through it. And you can see all the stuff that's been filed, here. And notice this case is 2 months old. and 2 months old, and we're on to filing number 74. This is very, very much out of control at this point. This is, and the reason why this is out of control is entirely because of this guy here, Tabor Benedict. I don't really fucking know. This guy, and then also, where is he at here? Bennett Susser, or Susser. I'm just saying he's sus. If I'm not saying their names right, I don't care. They're retards. These guys are Stuttering John's attorneys. These two idiots are Stuttering John's attorneys right here. These guys have inflated the docket, and this docket has turned into a complete dumpster fire. This shouldn't look like this at this point. If this was, I don't know, you're suing Google, and you're suing like Oracle, and you're suing, I don't know, Samsung, and whoever else you could sing or think of, I could see a bunch of filings coming up. But what these guys have done, they have just gummed up and shitted up this record. And this has caused the attorney for Karl and Shuli, Danny Cevallos, to have to respond to all this retarded shit. I mean, look at this whole thing here. Yeah, there's like one spot where Karl and Shuli's attorney had to respond to a bunch of retarded stuff, and then they file more retarded things, and then Karl and Shuli's attorney again has to respond to all the retarded things that have happened. This is absolutely ridiculous at this point. So, and this is just the incompetence of it. If you can, cleanly filed things don't require a gajillion things to get put in the case. Nothing has been decided yet. Stuttering John is trying to amend his complaint. That still hasn't been granted yet. And in the meantime, Karl and Shuli's attorney has to respond to all of this, because if you don't, you could be deemed to have waived and acquiesced to it. So it causes problems. Officially, this thing was started August 7th when the complaint was filed. Okay. But ultimately, service didn't happen until the end of August. So in reality, guys, what does this mean? Karl's attorney and Shuli's attorney jumped in the game basically on the, how many days are in August? Let's see here. There's 31 days in August. He jumped in on the last Friday in August. The 29th was a Friday when he started filing all this shit. I mean, so we've only been at this a month. And we're already to this point, really. Because you could argue, and I'm trying to spot Stuttering John a little bit here. The first month he was trying to get service. But notice, they filed a complaint, they amended their complaint, and now they're fucking around with everything. And notice, this basically all happened within a month, and we're just now to the end of this, and nothing else has been filed, thank God. I'm surprised the court hasn't done a thing where we see this in some of these lolcow lawsuits. Stop filing things until I make a decision. That happens. Surprisingly, it's not happened here. If I was the judge, I probably would have filed something saying, quit filing shit until I make a ruling. Yes, TSN is the Shuli network. Yes, TSN is the Shuli network. And Shuli is Shuli Yeager. He is the guy who used to work on Howard Stern. It was a comedian, like an actual comedian, who actually did work for Howard and wasn't just like, something to throw peanuts at. Stuttering John. Stuttering John was the geek at the carnival biting chickens' heads. Heads off chickens. Shuli actually was like part of the show. And I know people have asked me this in the meantime. Shuli and Stuttering John were not on the show at the same time. Stuttering John is like the old Howard Stern and like the traditional, like the rise of Howard Stern. Shuli came on years after Stuttering John left. How is this not sanctionable? Because the court hasn't gotten in the way yet. At some point, if the court does want to jump in, it should. But I just can't imagine the judge is sitting here looking at all this and says, "Oh my God, this is fine. This is fine." No Sir San is saying, "Can this be called malicious litigation?" I think you mean vexatious litigation. Not yet. Not yet. And can attorney's fees be asked long before the case starts? There are times. Well, you can ask for attorney's fees right off the bat and say, "Your Honor, we're seeking attorney's fees should we win," if you're the defendants. Now, what they could do at some points is, if there is a motion for sanctions or an order to show cause and the attorney on one side fucks up or the attorney on the other side fucks up, by causing, like, for example, if Stuttering John's attorney does something retarded and Karl and Shuli's attorney has to respond, they can seek attorney's fees for that motion and the hours and time spent responding to it. That is a normal way for the court to handle things. I think that's what you're asking. If not, let me know. Geez, I was doing good all day. Now I got the sniffles again. I'm like starting to sneeze my fucking head off. Let's see here. Yes, Stuttering John calls Shuli the shitware, which I don't. Yeah. So let's move on. There is some interesting stuff here, and we're going to move on to the first thing. And this was a lot of stuff filed by Karl and Shuli's attorney that we're actually going to get into here, because remember, we went through all the stuff kind of that happened at the last show. Stuttering John himself having like 4 different affidavits, which still doesn't make any sense to me. Like each day he did a new affidavit. I don't understand the logic behind that. And then there was the whole issue of all these affidavits of Stuttering John's witnesses, and they're all literally copied and pasted. You're like, how does that? That's not independent establishment of facts. You'd almost call that borderline perjury, but it's at least sanctionable conduct, and you should have those stricken. But yeah, we're not there yet. So I'm allergic to dogs. I am allergic to animal dander. If it's a shedding dog, like a short-haired dog that'll shed, oh my God, it'll fucking kill me. You lock me in a room with like a golden retriever. Oh man, it's bad. So, as we go on here, guys, remember this is right now currently filed in the Supreme Court of the state of New York. That's the trial court level. That's how they call it. And remember, New York's Supreme Court, their highest court in the land, is the Court of Appeals. In the county of New York, remember, this is in Manhattan. Stuttering John, he's like, I got my big city Jew lawyer. It's probably how he would say it. But yes, we're filing it in Manhattan because it's I'm a comedian, and that's where I go. I go to Caroline's, in the Comedy Cellar, and I'm going to be doing all this stuff. And, he thinks it's all retarded. And then it's against Karl and Shuli. I still, from what I understand, I don't think Shuli has an A in his name. I thought it's just Shuli, but I don't know. So anyways, this guy here, Philip Russo, comes on and he does a affirmation. Well, it's basically an affidavit, more or less. And he says, I'm a producer for the Shuli Network, and I work with Shuli. My duties include monitoring, viewing, and recording plaintiff John Melendez's publicly broadcast video, audio, and other materials. I hope you get paid well. Imagine that, like, somebody comes up to you and says, I need you to watch all this really gay bullshit. This man, my hat's off to him, because I'm not sure I could do that. I mean, how much of Stuttering John can you want to watch before it's just, and you're just like, maybe today, old friend, maybe today. I don't know how that will work. I don't know how you can do it, but that's Brave man, brave man. So, so he says, I've also, I've reviewed the attached link and audio file. Kate hasn't been paid yet, which was intentionally broadcast to the public by Stuttering John. The file is dated 2/5/25, and it's available here. And in it, Stuttering John does talk, and we're going to watch this real quick because it is available. So we're, well, if it loads. All right, here we go, chat. We're going to watch this. So here we go. This is part of Stuttering John's podcast. You know, he's the Duke. I don't know what the Duke of douchebaggery or something. I'm not sure.
What has Shitway done for her?
So, and then he, I do like this. No super chats will be read under $4.99. I mean, no super chats under $5 will be read. How many super chats does he get over $5? I mean, he must get a $5 super chat, and that's like me seeing a red boy up top, like, oh my God! Yeah. So anyway, yes, here's Stuttering John with his, his spank bank. I think this is that Kate Meany chick. But anyways, here we go.
What has Shitway done for her? He hasn't paid her anything for any of these tapes, but she somehow wants his attention, which is sad.
That was it. But it's important. It's important for that. And they say, what has Shitwayer done for her? I hate this when they do that. Like, just use the fucking swear word. He hasn't paid her for anything in these tapes, but somehow she wants his attention, which is sad. I think it's funny because you were like apparently so desperate for Kate's attention, you let her keep fucking raking you with this shit repeatedly. Yeah, that's man, it's a lot of fucking self-report there, John. A lot of self-report. John Melendez refers to knowing and intending that Miss Meany provided the phone recordings to Shitwayer, and also they state Shitwayer is Melendez's derogatory term for Shuli, which is commonly known in the podcasting community of broadcasters who cover John Melendez. And then he says, he refers to knowing and intending that Kate provided the phone recordings to Shuli. Stuttering John uses this as a nickname for Shuli. This is commonly known among the podcasters who cover it and report on Mr. Melendez, who is without question a person of public interest to many people. It's very nice how they did this. It's very nice how they did that. They could have just said he's a fucking lol cow, but they didn't. I know from Shuli covering Stuttering John that Stuttering John is aware the defendants frequently broadcast reports and commentary. I recognize the speaker and the person in the video as the plaintiff, Stuttering John. I've reviewed the video, and there are fair and accurate representations of the broadcast I recorded. And this is him just stating, yep, I did it. And yeah, that is that. But that's this is how do courts have time for this crap? Because people file it. The American court system is based on the idea that you're not precluded because you might be poor or you might be unsophisticated. It's meant for the common man to be able to seek redress in the court system. That leaves it open to abuse. But that's the trade-off. So that's the trade-off. Yes, and Andrew Kelso, as I had to learn the last time, yes, he didn't just touch the hot stove. Yes, he started doing burpees on it. Yes. No more 400 chats on screen unless they pay. For that too, we'll do that. Yes. Hella, yes. Sorry, Hella. Might. Yes, Chili de Castro is a great example. Chili de Castro is a great example of people who abuse the system. So moving on from there, their attorney, once again, like I said, this is an example of really good attorney work versus really shitty attorney work. And Karl and Shuli, they did the right thing. They got a good attorney. And I've told you before, guys, when you get an attorney, you want an attorney who's not like you. You want an attorney who's different from you, personality-wise, and maybe even thought-wise, because you want them to be able to push back. But also, you need to be able to push back against them because as a client, you're supposed to converse with your attorney and talk about strategy and have game plans. When you are a lolcow and you hire a lolcow yourself, well, you guys are just going to do retarded shit and crash and burn. So what happened here? So this is Danny Cevallos of Cevallos and Wong talking about this is his opposition to the motions that were filed. And they point out a bunch of things here. And this isn't very long, guys. And it's actually hilarious the way he phrases all this. I will give this guy credit. He is very sharp with the written word. This is where Stuttering John moved for a stay and for the expansive discovery. Remember, Stuttering John's asking for discovery so he can really dig into the amount of money and things that Karl and Shuli have made so far. And he wanted to go already start doing discovery prematurely like that. And it's just so Stuttering John can fuck with people. That's all he wants to do. That's all he wants to do. And this is the opposition to it. And they point out that the civil rules do not authorize you to file standalone motions to stay other motions, which you're supposed to know your rules if you're going to do this stuff as an attorney. They say, moreover, they're trying to obtain a fishing expedition into Karl and Shuli's sensitive financial and business information. Stuttering John insists the discovery is limited and targeted, but the court need only look at the actual discovery they seek. It's anything but limited and targeted. Yeah, they want like everything. They want everything. It's an attempt to intimidate them and, basically let Stuttering John look through all their shit and then post it all over the internet. That's all this is. It's not right aligned, but you know what? This guy does a good enough job. I give him a papal dispensation. I give him a dispensation for it. I don't like it, but you know what? We can't win on everything, but if you're effective at what you do, I'll let it slide. And they point out this is the opposite of what the anti-SLAPP law is designed to do. And remember, they are going forward under an anti-SLAPP because Stuttering John's doing this because of what they said and did. And it's to protect defendants from oppressive discovery. Not open the gate for a strategic lawsuit against public participation, which is what SLAPP means. Stuttering John to go on a fishing expedition before the court decides the anti-SLAPP motion. And that's correct. Let the court decide its motions first. They talk about a couple different things here that the memorandums put together are not sworn, and it cannot serve to demonstrate the reasons why they can't present facts. And yes, if Stuttering John didn't swear it out, it's worthless. They refiled motions, and yes, this is a big thing here. Stuttering John filed nearly 80 pages of his prior filings. It's unnecessary and cumulative. Yes, it's bullshit. Once again, these guys are just shitting up the works. And when you do that, the other party has to respond. And this is where it's actually pretty good. I like some of the stuff here. So they say Stuttering John demands an opportunity to obtain basic discovery into the fundamental profit-driven nature of their enterprise. As discussed in the defendant's memo of law appended here too, Stuttering John has not demonstrated specific reasons why he can't present facts essential to justify the opposition. And even if he did, the discovery he seeks is not the limited discovery that's permitted. And they say the affiant specifically states that discovery will grant Stuttering John the ability to gather facts essential to his opposition, the facts which are exclusively within the defendant's possession and control. And here's, I love this. Specifically, but then follows with a general statement, discovery will let him gather facts essential to his opposition. It's not a specified reason, and I agree. It's not a special reason. He then argues that this provides a clear path forward, a stay of the motion, and a proper showing, limited discovery into these issues. And they say, as they point out, though, the stay is of the proceedings, not of the motion. And from here, this is where it gets, like I said, the logic and the destruction of Stuttering John's point is very well done here. So this affirmation, they call an affirmation, calls it a targeted and narrowly tailored discovery. We went through this before. No, not at all. Not at all. And like their revenue, their business plans, like you're asking for fucking everything. That's not narrowly tailored. But but the defendants asked the court to look at what they're doing here. The precise manner in which they monetized, all this stuff. That they're asking for everything. And they point out, what do the business plans of revenue have to do with plaintiffs' counts 1 through 3? They already allege that there was profit from the alleged use, and this is where it's great. Bring in the receipts. Look at it. You could almost argue this is Passim. Throughout the entirety of Stuttering John's first amended complaint. Yeah, and here's the thing. You don't need to prove actual dollar amounts yet. You're not necessary to oppose motions at this point. And then the plaintiff then reveals this broad discovery is not warranted when he states this narrow tailored discovery is essential to ensure this court has a complete record and to make an informed decision. And they say, the anti-SLAPP stuff doesn't contemplate completing a factual record. It contemplates the possibility of only limited discovery and only if the plaintiff comes up with the reasons why. And that's the thing. Like, this is at the very beginning of a case. You're never going to have a complete factual record. You need all the discovery to get to a complete factual record. You're not going to get there. You're not going to get there. You're not going to get there at all. You're not going to get there at all. They also talk about he can't refer to his proposed second amended complaint. They say, as in his other filing, Stuttering John attempts to have the court consider the proposed amended pleading. And that's because it's only been proposed. It's not actually in here yet. And I think that's important because it hasn't been admitted or given leave to be filed. If it's not part of the case yet, it doesn't exist. You can't refer to that document because it's not been the court has not admitted it yet. And it's his now third. It's the second amended complaint, which means there was the complaint, the first amended complaint, second amended complaint. We're on number 3 now. We're on number 3. So they say, for example, they're arguing it strengthens the underpinnings of his claims. That's not a reason. You've already had 2 shots at this already. Clarifies the unlawful recording conspiracy in even greater detail. Once again, I don't think these are legitimate reasons to amend. You already knew all this stuff. You are not learning new information. This is just, you did a really shitty job and now you're trying to backfill. And I don't think they should be granted this opportunity. And they point out that this is not the operative pleading, meaning it's not the one of record. The first amended complaint is the one that controls. And they say that motion to amend has not been granted. And that's true. Until it's granted, it's not a filing that exists that you could consider. It's not a filing you could consider. And it's opposed by the defendants, as rightly they should. And further, it's all stayed by the anti-SLAPP stuff. And the court shouldn't consider it. I agree. For example, the court should not consider the conspiracy because that word does not appear in the first complaint, the amended complaint. Only appears in the second. I agree. Stuttering John's arguments have nothing to do with financial record discovery. Notice the stuff they talk about in support of the discovery and this is from the second amended complaint. We went through a bunch of this. They say that this was, the private tapes were obtained without his consent in contravention of the two-party consent laws in California. Where was Kate at the time? We never established that. So these could be legal, and even then, if they're not, you're gonna have to show what that means for your case, John. The second amended complaint also joins Kate Meany as an additional defendant. For who carried out the recordings as a co-conspirator. Dun, dun, dun! By bringing Kate into the case, it now encompasses all known participants in the alleged scheme. You could have done that before, and you didn't do it. Once again, as you guys explained to me, apparently Stuttering John is still trying to, get a chance to sniff her seat. And because it sounds like it didn't happen, he got really, really mad. So... let me see here. Oh, hold on. So they also point out the addition of Miss Meany combined with the allegations, the enhanced factual allegations. They're not really enhanced. You add in more words. That's not an enhancement. Brevity is the soul of wit. Shorter is better. It provides a more complete and robust. We're getting a Dark Side Phil territory here. It's a robust urban garlic flavor in Stuttering John's claim. Every time I see the word robust now, I immediately hear it in Phil's voice. I'm in trouble. I'm in trouble, chat. I'm pretty sure Seat Sniffer is the next Metal Gear game. I say none of this has to do with the discovery that Stuttering John seeks. And yeah, once again, they want revenue, business plans, and the manner in which they monetized, which means he wants access to all their analytical data. Everything they did, merchandise sales, everything. And they say the one-party, two-party states alleged illegal recordings. None of this begins to offer a reason why Stuttering John can't oppose the anti-SLAPP. And it says to the contrary, 20 pages of his memorandum and the 29 pages of the first amended complaint demonstrate that Stuttering John has plenty of information. He does. He has all kinds of information. His burden in the anti-SLAPP is to show that it's not a SLAPP motion, and he has a substantial basis for his claims. And this is funny here because he's saying, what this means, John, is you should focus on establishing that counts 1 through 3 are valid causes of action. They are not. I don't think so. John doesn't even dispute this, but John is instead trying to get broad discovery, which would be relevant to nothing except causing problems for Karl and Shuli. And he said detailed discovery would not help Stuttering John meet his burden and show that his lawsuit has a substantial basis. And he has no specified reasons. So, yeah, there's nothing here. It's nothing here. I don't know if they're going to survive. That's the one thing. Because the anti-SLAPP's been filed, do I think is the court going to err? I'd like to hope the court won't, because this is more than just a motion to dismiss now. We're in the anti-SLAPP territory. I mean, I've been thinking about it more and just seeing how much the docket is ballooned. I think the court may just wash its hands and say, fuck it, anti-SLAPP's good enough, and make Stuttering John suffer, and then just kind of move on with its day, which would be the right option. But once again, remember, lol cows have a unique ability to survive in their lawsuits for a while. So, and they say, Stuttering John says the SLAPP is typically in defamation, and Karl's attorney says that's not true. SLAPP suits are not necessarily defamation suits, correct? There are scores of cases in New York in which they're brought in response to other types of lawsuits. And public interest in regards to the anti-SLAPP statute is broadly considered to embrace matters of political, social, or other concern to the community. Now, Stuttering John tries to say, well, claiming it's anti-SLAPP case cannot simply say it's conclusory and their burden is met. And they're like, yeah, we agree. That is why we filed a notice motion, affirmation of facts, and a memorandum of law, all in support of the anti-SLAPP motion. And they say this is a SLAPP lawsuit for the reasons in those moving papers, meaning the motions, and not because the defendants say so. This is kind of funny here. Stuttering John argues this was for profit, but the quantification of that profit is a fact solely within, the defendant's knowledge. Whether it's true or not, it has nothing to do with whether Stuttering John can prove that they have a substantial basis in law. And they talk about all the things he wants, but never offering the reasons why. And this is, the other stuff. They want the ticket sales for DabbleCon 2, the pay-per-view for Dabble House. And this is the in-depth super chat donations, live streams, merchandise sales, data on the number of subscribers and paying customers and their geographic locations, which that would be entirely used by Stuttering John to dox and harass individual people. And they say, why is any of this essential? And I agree, italicizing that. Why is any of this essential? Why does Stuttering John need this to oppose the anti-SLAPP? He already says that we profited. The precise amount has nothing to do with whether or not this is a SLAPP suit. This is this is 100% correct. And I love how he does this. You don't need any of this shit. And then says Stuttering John then exposes himself, which I'm sure that's not the first time that those sets of words in Stuttering John's name have been used together. Without this data, John is left to argue against a factual assertion of public interest without the very evidence that would prove it as a commercial venture. I wish I had the... It's like Terminator. Wrong. Hey, you can't do that. Wrong. For many reasons. I just love that. Wrong. First, the mere fact that newsworthy or other protected use is profitable does not divest the use of newsworthiness. And second, the plaintiff already alleges that they had a commercial venture. They don't need any discovery to allege that or oppose the motion. They want to get in, then they say that Stuttering John wants to get in the profit-driven state of mind. He doesn't need discovery for that. He's already alleging it. He's already made the claim these guys are driven by greed. The plaintiffs then admit that the FAQ, the First Amendment complaint, alleges a coordinated scheme. But then Stuttering John alleges he needs discovery and subjective motivations and strategic planning behind that scheme. Say, isn't the subjective motivation behind the scheme the alleged profit? Yeah. I mean, you've already alleged it. You don't have to prove it to a, preponderance of the evidence standard right now. You don't have to do that. That's not required. And then Stuttering John says these materials will uncover direct evidence of how they viewed the illicit recordings. And they say, hasn't the amended complaint already alleged how they viewed the recordings? Yeah. We already heard that. They had the show, and they had DabbleCon, and then they had Dabble House. And they did all this gay shit, to do it. They already did it. The First Amendment complaint alleges they broadcast them, interspersed comedy and commentary. Yeah. We've already done that. And they said the realistic fear that Stuttering John will dox the defendants. And yes, from what I understand, you guys have explained, Stuttering John loves to dox people. This is something John does routinely on his show to retaliate against perceived slights. So he threatens a fan on September 18th. And this got filed on September 18th. That is brilliant that, this literally just happened, Your Honor. Brilliant fucking work, John. Brilliant fucking work. So, for example, he doxed a fan who he believed was showing him disrespect Then several minutes threatening him, saying he was going to come find the fan. I mean, like, that would be funny, but, like, eventually, like, he's going to threaten people and come after him. He's going to do it in a state where people can kill him. Although if you kill, like, if somebody were to kill Stuttering John for coming after him, even if they just beat him. I mean, he's an old alcoholic. That stuff, you know, he's going to be fragile. It's going to be like glass, man, if you hit him. I mean, shit. Like, it's like, I love it. He's like, I'm coming for you, you fat lawyer fuck. It's like, I would finish the 40mm launcher, and then I would splurge like $1,000 for like one of the 40mm less lethal rounds just to hit Stuttering John with it. He came to my house. But he already talked like he, you know, has done this stuff. Like, he's an absolute fucking lunatic. He's an absolute fucking lunatic. He can't be trusted with sensitive information. Like, that is 100% true. And here is Stuttering John talking about one of his the beanbag round. I thought about that, but I used one of the other baton rounds. There's all kinds of things you can do.
I see this Jordan Jackson is already, now he's really getting egregious and starting some nefarious behavior. So let's go over our dumbass of the day, shall we?
Stuttering John will not read up or put any Dabbleverse related posts. Management. Why do you have to tell people? Just fucking ignore them. Why do that? Why do that? Harbor Walber says, do 40mm or less lethal rounds exist? Yes, they do. Yes, they do. But this is just like, I don't fucking understand this with this guy.
All right, dumbass of the day. We go. There he is. There he is.
No, there he is, I guess. There he is, Chad.
Dumbass of the day. There he is. There's Jordan Jackson. Jordan, let me tell you something.
It looks like he owns a pontoon boat, which, I mean, how many boats do you own, Johnny boy? The guy owns a boat. Guy owns a boat. Looks like he's up in like the Pacific Northwest, maybe. But like, do you own a boat, John? Do you even own a life jacket? I'm just saying, for like shit talking, I don't get it. But all right.
I don't think you really want to continue down this path because now I know what you look like. Now you might think, well, I'm going to tell the club to not have you enter. No, that's not going to be the case. I'm going to look out for you, though. I look forward to running into you. Put it that way, tough guy. And by the looks of you, you're going to need help. YouTube's terms of service. Of course, I'm talking about our conversation. It looks like you're going to need some help. What do you think? I think, though. Thank you, Crackhead Bob. You're welcome. Yeah, I don't think you want to take these on, okay, Jordan? I don't think so. You know, in a gun show, of course. Those are fucking guns, motherfucker.
Fucking cap guns, okay.
I was in the gym today. I was doing arms and chest. I was looking good.
I have a feeling I could throw an open beer on the ground and you dive for it if you try to confront somebody on the street. So.
And before you start saying anything, my grandfather used to say, looking good, in his Hispanic accent. So I'm trying to do it justice. He was from Puerto Rico, you see. You see what I'm saying? Looking good. But here he is, dumbass of the day, Jordan Jackson. That's right. And I have more where these came from. Jordan, I don't know, man. I don't think I'm the kind of guy you want to fuck with. That's all I'm saying. Trust me. Trust me. Ask Lardif. Ask Lardif if you don't believe me.
when you start telling people like you're that hard, it's like you should really be sure that harder men haven't tried to hurt those people. Just saying, just saying. Do the words behind him say the Dyke? No, the Duke. He's the Duchess, more like, but yes, he's the Duke. The Duke of what? I don't know. The Duke of douchebaggery. So, but no, as he's sitting there like doing this, I just imagine that scene from The Departed where Jack Nicholson's like staring down the barrel of his pistol, and he like drops it, and he's like, "Oh yeah, What was that? You were saying something about threatening to kill me?" So yes, the Duke of Dick Sucking. Does that mean he's taken the throne away from Legal Mindset? Oh. Oh, we got a tower going, chat. Ooh, keep it going. There we go. All right, just getting back to this real quick, guys. We're almost to Russell Greer here. Just going through a couple things real quick. So they just point out that, look, when the plaintiff asks for is dangerous, it's exactly what the anti-SLAPP is designed to stop, not encourage. So what do they want to do? The plaintiff only describes the intrusive financial discovery he seeks. He calls it crucial, but never provides a reason for it. Yes. Wait, what happened 48 minutes ago? Oh, you're saying, oh yeah, with Clyde and Bonbon. Sorry. When he said James Reeve, I almost said James Reeve, like the Fire Art blog, like what happened? So yeah, legal dick suckers more like it. Well, if Stuttering John passes the LSAT, there we go. So they've gone on through this. They've gone on through all of this. They filed another motion, and this is like all these cross motions and memorandums in opposition. This is just, it gets ridiculous how you have to file all this shit in New York. Just the way everything's labeled and all this. It's on and on and on and on and on. And once again, Karl and Shuli's attorney has to waste money defending against the bullshit from John's attorney and John. So, and they just go through and like, you can't use an anti-SLAPP motion to stay an anti-SLAPP motion. It's like, can't double stamp a triple stamp. You can't use an anti-SLAPP motion to stay an anti-SLAPP motion, which, yeah, it's kind of interesting. They say what they're not entitled to discovery. And just once again, they kind of explain all the stuff we already did here. I just going through this because I know some of you are going to say, well, we didn't talk about this one. But they just point out, this is an anti-SLAPP lawsuit. And I think the affirmations or the affidavits that accompanies are far more in depth. So I liked using that instead of this. But this is kind of the same thing here. It's once again, fighting the anti-SLAPP motion. So from here, there is some stuff that happened. So Benedict Advisors, once again, this is Benedict Advisors. I'm not sure what advising they're doing, but this is to the judge. Remember, guys, this is the East Coast, so especially the Northeast. Letters are a typical method of motion practice. In Andrew Kelso says, what's the SLAPP anti-SLAPP? So SLAPP is SLAPP. I said PP. So that's a strategic lawsuit against public participation. So, for example, a celebrity could sue a little guy for defamation, or they could sue him, like in Stuttering John's case. You're using the lawsuit to silence negative things about you that are perfectly normal. So Karl and Shuli are publicly participating. And Stuttering John's lawsuit is solely to shut him up. Remember, we talked about that previous thing where Stuttering John's attorney came in and said, look, if you guys just let this go, we're all cool. And you're like, absolutely fucking not. Absolutely fucking not at this point. Like, are you serious? Just let it go. Just let it go. Just walk away and we're all good. So that is the strategic lawsuit against public participation. What that is, then you file an anti-SLAPP motion. It's an anti-SLAPP motion. You're saying, like, look, this is solely meant to come after us, and this is very clear here. This is very clear here. Like, notice this is what Stuttering John wants. That's all he wants. They are willing to seek a resolution of this matter. And what's the resolution? So long as the defendants agree to refrain from using Stuttering John's name, image, likeness, and audio and visual persona. That's all Stuttering John wants. That's all they want. They've already offered this. So this already just shows you how fucking garbage this whole thing is. We're already at that point. We're already at that point here. And this is just further proof of it. It's further proof of what's being done here. So that's what SLAPP is. That's what SLAPP is. I hope that explains. And many states have anti-SLAPP statutes, meaning if you're served with a lawsuit that's chilling your speech, you can short circuit the process and right off the bat, almost before a motion to dismiss, you can challenge the lawsuit. And if you win, you get attorney's fees and you can get your own damages, depending on the state. Some states have very tough anti-SLAPP statutes, which are really robust. Then there's also some states that still don't have one. Ohio just got one this past April. So it takes time. Not every state has one. But anyways, this is the lawsuit. Remember, guys, this is the case filing, all the information. Remember, this is how, like I said, the Northeast, you do stuff. That's when I say East Coast. I don't mean the, like in the South. That's still on the East Coast, I guess, technically. But yeah. So the dear judge, he's saying, we request an adjournment, meaning a continuance or a stay, of all pending motions to allow proper briefing schedules following the defendant's systemic violation of the timing requirements and to accommodate scheduling conflicts, including religious observances and counsel's travel. So what are they doing here? Well, remember, you have to meet and confer if you want to get something done in the civil arena. You meet with opposing counsel and you confer with opposing counsel. You're supposed to do that. And if you don't do it, it becomes a problem. It becomes a problem for them. And if you can't agree, you come to the judge and say, Judge, look, here's what I wanted done. I met with the opposing party. We wouldn't agree. And this is where they start off. He says, we've made consistent good faith efforts to ensure proper notice and judicial efficiency throughout this litigation. Are you fucking kidding me? You know, my little hatted nibba there. Like, we're at number 74. We're at number 74. This is not efficient. This is a fucking disaster zone already. This is a fucking disaster. So there was a cross motion, the leave to amend, which once again, they should not get. They should not get this leave to amend. It was filed September 10th and properly noticed for September 19th. They provided 9 days notice exceeding the 7-day requirement. They requested consolidation with the pending dismissal and venue motions. And they offered the defendant stipulation opportunities for reasonable scheduling. You know, what they did for as far as the anti-SLAPP stay. They filed it September 15th and it was noticed for September 23rd. These requirements, like I said, this is all weird to me because we don't have this. There are no note, like you don't do it like this here in Ohio. Like I said, these states, especially like New York and some of the East Coast, these Northeast states are very rigid and structured in how they do it. So it's interesting to see. Like I said, guys, I enjoy this because it's learning how these other states do it. And I'm like, fuck, man, this is ridiculous. It's not like that here. They provided 8 days notice and there was a 7-day requirement. And once again, they wanted to consolidate motions and they offered stipulations for a later return date. And they say that the defendant's procedural violations. Despite the professional courtesy and proper notice. Oh, yeah, because this is... You guys are professional. Are we sure about that, Benedict? Tabber or whatever the fuck... I don't even know what the fuck your name is, dude. Tabber... Like, what is his name? Yeah, Tabber Benedict or Benedict Tabber. I don't even fucking care. You don't rate for me to even remember it correctly. You know, and I thought he was leaving, and the other guy who's the shitty stand-up comedian was coming in. Sorry. From what I understand, that could be Stuttering John, too, as a description. But the attorney who dabbles in stand-up. So they filed it on September 10th, properly noticed it for September 19th with 9 days' notice. The defendants filed an opposition at 11 p.m. on the 18th, 5 days after the 7-day deadline. This denied plaintiffs' right to file reply papers. Like, okay, well. The anti-SLAPP stay. The defendants again filed at 11 p.m. on September 18th, 2 days after the 7-day deadline, again denying adequate time for reply preparation. I mean, that's your fucking fault. You're bombarding them. The pattern violations. The third instance where defendant's counsel has either initially scheduled inadequate notice periods, rejected reasonable requests, or filed last-minute opposition papers. If that's not a violation of the rules, then it's not a fucking problem. Plaintiff settlement overtures and stipulation offers were ignored. Remember, this is their settlement overture. Leave me alone. Like, fuck off, man. Fuck off. This is just retarded. This pattern suggests deliberate tactical gamesmanship. I mean, once again, a fucking self-report. Once again, another self-report there, chat. They also talk about consolidation and stipulation efforts. You're the ones who have gummed this up and blew it up. There's been offers for later return dates, and they, without response, have forced piecemeal litigation. Well, they don't have to fucking comply if you're being dickheads. Then he says there's scheduling conflicts. He's got travel. I don't know how he didn't know about this ahead of time, but it's kind of like the whole thing with Aaron's attorney. Scheduling conflicts happen. And I know there was somebody who's reviewing my thing saying, well, shouldn't you know your attorney, your client's got a sentencing hearing? I'm like, you got a million fucking clients. There's a million fucking sentencing hearings. There's a million fucking this. There's a million fucking that. Like, shit happens. That's not properly calendaring things or messing up happens. Courts do it. Courts will mess up a date. Like, I got a notice yesterday saying, hey, we got something set for 10 a.m. tomorrow. We can't do it. We're going to bump it back to the other date that was set for this on the 8th. Like, I don't know I don't know what happened, but it sounds like they miscalendared something. And it wasn't, it was my case and another case. Oh, whatever. I can't do anything about it. Shit happens. Shit happens out there, guys. You forget to file a TPS report. Cover sheet on your TPS report. Things happen out there in the world. Yeah, hold on, chat. I'm going to do this. So, am I Tommy Tudor's lawyer? Fucking. Oh my God. I will cut my own. I'll cut my fucking head off with this if I were to do that. Don't scare me like that. Don't scare me like that. So lead counsel is unavailable through the 20th through 11th. I mean, that happens. But notice, lead counsel, that means you have a second chair or a co-counsel. Why can't they do it? If you were the only counsel on it, this may be a more compelling thing. Are there Jewish holidays? Yeah. Now, these Jewish holidays are occurring in the time frame while this guy's gone. But I will tell you, Jewish attorneys, if that happens. Like, hey, Your Honor, I can't be here. We have Rosh Hashanah. We have Yom Kippur. We have Sukkot. Those are all days. Now, there are some problems here. There are some problems. We talk about like the Jewish holidays here. There are some Jewish holidays, yes. These are all actual real things, chat. These are not made up. If you're not a follower of the Little Hats, Yom Kippur, Rosh Hashanah, and Sukkot are real events. The first problem, though, is Rosh Hashanah is the 22nd through the 24th. It's like, and I've been in court before where the attorney's like, Your Honor, I can't be here that day. It's Rosh Hashanah. And, the court says, cool, we'll move around that. But that also happens, chat, where I've been in court before where there's an attorney and I didn't realize he was like very devoutly Catholic, and some stuff was getting scheduled during Holy Week, and he had to tell the court, like, Your Honor, I go to mass throughout Holy Week. There's a couple different days, and the court's like, cool, we'll fix that, not a problem. Sukkot is 6th through 13th. And then Yom Kippur is October 1st through 2nd. So the middle of Yom Kippur right now. And if you guys aren't really sure, like, well, what's Yom Kippur? It's like, well, they fought, Israel got attacked by the Arab states on Yom Kippur and got their fucked. They got mauled really bad before they won. It was actually kind of like a very, very, very Pyrrhic victory ultimately. But, that's an acceptable thing. And, adequate reply preparation. The late filings require proper time. That sounds like that's your fault. It sounds like your fault. Three-way war in one, yeah, but they paid dearly for Yom Kippur. This wasn't like 67. And for comprehensive replies addressing the complex constitutional and statutory issues. So they want more time. They want more time on this. They don't want to adjourn all motions to the end of October. They want to strike untimely opposition papers and proceed on original motions only as an alternative. Fuck that. Fuck all that. They require, they're pointing out that they require opposition papers to be served at least 2 days prior to a return date. The violations are clear and prejudicial, leaving John with fundamental reply rights and forced reply rights. Yeah. Stroke mouth there. Inadequate preparation time for complex legal issues. Well, how does having 2 fucking days help you then? And they point out the systemic violations. 3 instances in 6 weeks. Oh, no. So they want to go forward with this. They show all the stuff that they filed previously, including, once again, this bullshit settlement letter that they offered. Absolute bullshit settlement offer. So, and then this is a attorney affirmation here. And they say, we're concerned with the tone defense counsel take issue with his misleading characterizations. Oh, no. And they say only after we pointed out the logistical impossibility of the overly short windows did counsel agree to an extension. Well, that's what you asked for. You asked for it. You communicate and you get it. I mean, why this is all highlighted? It's so fucking retarded. The reasons we did not want to extend motion practice further include our concerns about the ongoing and continuing damaging activities of the defendants in breach of New York and Florida law, and the defendants knowing of a likely lawsuit for several months. So it doesn't matter if you know of a likely lawsuit. If you haven't filed, fuck off. Did you file a notice of preservation? Did you do anything like that? No. You filed a couple of limp dick cease and desist letters. I tell my clients to fucking ignore it too. We continue to have internal talks. We're having internal talks. What you guys talking to Stuttering John, I'm sure that's productive. About how to stop the defendants from further increasing damages to our client pending this litigation. It's so fucking gay. So fucking gay. Like this is I'm not even. This is just this is all just retarded here. This is all just retarded. I can't. I reading through all these emails here, this is just, like, fuck these people. Fuck these guys. I can't, like, you can't take this man seriously. I can't take this man seriously. You can't take this man seriously at all. You can't take this man seriously. So, and the funny part about this is, the funny part about this is these two things that got filed here. When you look at this, 72 and 73 are the same fucking thing. They're the same fucking thing from what I can tell. Just by glancing over them at 10,000 foot view. So it's like, why do we have the same two fucking things here? This makes no fucking sense. Once again, this is always more garbage they're inserting into this whole fucking mess. Absolute garbage by John and his attorneys. Just hot fucking garbage. And then Karl and Shuli's attorney comes back and fucking hits really hard. So here's how this goes. I love how he starts off with this brief summary. Hold on one second, chat. Sorry, guys. I'm making sure 2.0 did not need help. And here's the thing, too. He says this letter is in response to the two letters to the court he filed on Saturday night. Yeah. And he's ultimately pointing out here, we object to the request to file replies to their motions. The cross movements are not entitled to replies. Stuttering John's attorney proposed, drafted, and agreed to a stipulation with the deadlines for filing these motions. And we already talked about this. They already did this, and he agreed to it. He's now complaining he didn't give himself enough time. And there are already enough filings for the court to decide at this point. Yes. There's already enough shit that's been filed. Remember, guys. Remember. All this shit has been filed so far. All this garbage. Like, there's enough here for the court to make a decision. There's more than enough here for the court to make a decision. We don't need anything else. And they say separately, though, they respectfully suggest a brief conference to address, the filing practices may be productive. And they're saying Mr. Benedict's filing practice may be productive. And the alternative to avoid a conference, the court can enter an order denying the letter request. It can indicate the motions are submitted and there are no further filings. And they point out here, in the week since he commenced this, Benedict has filed documents on an almost daily basis. And that's true. I mean, like, tons of shit's been filed, guys. This is a weird lawsuit that I've almost every week this past month, I've been able to talk about this. And he says, I regret sounding critical of counsel here, but several of these documents are procedurally unorthodox. And that makes me like, if a New York attorney, a guy who lives and breathes the system, is confused, I can't, like, how does anybody figure out what the fuck is going on here? How does anybody figure out what the fuck is going on? Many are completely irrelevant to the issues. Some are just indecipherable. I'm glad I'm not the only one. I've been really fucking confused about what's going on here. And I'm a retard out in the middle of, I'm a shit-kicking rube out in Ohio. This guy doesn't get it either. I mean, these big New York City lawyers. And they say, for some examples, Mr. Benedict has misfiled memoranda and affidavits, which he admitted to, creating yet more filings. He's filed affidavits from plaintiff's mother and his friends to attest to their belief that Stuttering John didn't mean it when Stuttering John consented to the alleged recordings and that Stuttering John's upset about them. There have been 4 affidavits by Stuttering John himself, which, once again, I told you guys, that is so fucking weird. About largely how he tells the court why he strongly feels his case has merit. Once again, I agree. It's not meant to be there. These are retarded. He filed a letter telling the court not to schedule anything during his trip abroad with the love of his life, whom we all know as Natalie. I don't understand that, thing here. I don't know. But yes, the Stuttering John stuff is inadmissible and not relevant. Inadmissible and irrelevant. Yes. I don't know who the Natalie is, but whatever. All these filings result in additional work for defense counsel in this court, who's made to sit through it all. The court does not have time for this. And I love that, he points out that court statistics show there are 41,200 civil cases alone pending before the New York County Supreme and Civil Courts. That's in Manhattan Island, guys. That's in Manhattan right there. 41,000 in Manhattan alone. Worse off, each of plaintiff's filings begets more filings because defense counsel must correct the misstatements with citations to the record, lest the court thinks defense counsel is ignoring or silently approving the filings. Yes, you have to do that. Unfortunately, Benedict will likely feel compelled to respond to this letter with yet another letter. Did he say about the judge in one of his letters? Oh, I mean, that's the thing. This Tabard Benedict guy, he's such a fucking flake. I forgot half the bullshit he says. He's a faggot. He talks like a faggot and his shit's all retarded. So, the near daily filings also follow a similar pattern. He makes a procedural gaffe, then tries to blame defense counsel for it. This is some Russell Greer shit here, and this guy's an actual attorney. Yes. Shuli is the hardship. The latest two identical letters were filed on Saturday, and like I said, this is what I thought. The last two are identical. In these letters, Benedict's opening sequence is alone rife with inaccuracies. First, the chief complaint is he didn't get to file replies to his cross motions. A cross movement doesn't have a right to reply. He chose to file cross motions knowing the return date would be the return date of the original motion. Plus, if he knew he planned to file cross motions, he could have built that in the stipulation he requested and drafted and filed. For whatever reason, he fucked up. Second, we have not systemically violated timing requirements. When they asked for more time, we immediately agreed and signed the stipulation. They got the extension they wanted without objection and without having to move the court. He's blaming us for agreeing to his request. And he says, third, the motions are submitted pursuant to a submission schedule that they agreed to in their stipulations. They drafted the stipulation, signed it, and e-filed it. It's also notable the stipulation contained no language contemplating or permitting cross motions, let alone setting a schedule. The defendants did not complain when these motions were not contemplated or agreed to. Rather, they just responded within the deadlines. And they say, fourth, the documents were late because they denied the right to reply. But meanwhile, they violated their own deadlines with late opposition to the original motion to dismiss. They agreed in the stipulation that he drafted, signed, and filed. And why do they point out that he drafted it? Remember, guys, if you draft it, it's construed against you. It's construed against the drafter. And they did this for a deadline for plaintiff to oppose a motion. So he wanted September 12th. On September 13th and September 14th, he filed and then misfiled 9 different untimely opposition documents. He says, while I pointed this out to the court in my papers, I readily acknowledge the court would likely accept the late papers because they were only a day or two late. And that's very common. A day or two late, yeah, close enough. Or as I learned on my one of my jobs before, good enough for who it's for. If Mr. Benedict is asking the court to disregard the filings he mistakenly believes are late, then the court should all disregard his late opposition papers too, and the defendant's motions are therefore unopposed. Oh, that's beautiful. That is beautiful. Fine, Judge, let it all go. Our shit's the only stuff on the field. Therefore, we win. And they point out this guy wants endless briefing, just back and forth and back and forth and back and forth. No, nobody fucking wants that. Nobody wants that. This case is 6 weeks old and there are already 73 filings. Enough is enough. The motions are submitted. The court needs less briefing, not more. And you guys, last night we talked about this in the Ethan Klein case. Some of you guys are sitting there saying, oh my God, this judge is a fucking asshole. Or he's a psychopath. This is what happens when you don't have fucking rules in place. This shit happens. This is why these judges do it. This is why these judges end up with fucking very draconian rule sets. Because they deal with bullshit like this and they don't want to deal with it ever again. So there is a method to the madness. What would be an average amount of filings? I don't know. I mean, like I could see in Ohio with something like this was going on. I could see like docket entry, like filing entry, like 20 to 30. That would be a lot still. It's only going to be a handful of things that should be filed at this point. This is just fucking nonsense that the plaintiffs have created. It's just, this is a ton more. And he says, as far as I know, this is the first time Benedict has invoked the Jewish holidays as a need for an extension. The only reason he gave so far is his vacation abroad with Natalie. He says, of course, I have no objection to religious holidays or vacations abroad. I do object him suggesting I somehow resisted a request to celebrate Rosh Hashanah, Yom Kippur, Sukkot. I never did. And suggesting in writing that I resisted the request for religious accommodation is inappropriate. Yeah, because he's trying to say, see, Judge Cohen? Judge Cohen, parenthesis, parenthesis, parenthesis. David, oh shit. I'm sorry, chat. Fuck. All right, we'll get down here. Yes. Sorry. And he says that I have no objection to holidays or vacations. And the idea that I would resist a religious accommodation is inappropriate. And notice that, yes, you know why the judge did that? Because when Tabor wrote this, he wrote, Judge Cohen, oy vey, Judge Cohen. Your Honor, the Judge David B. Cohen. He's my son, the lawyer. Parenthesis, yes. Hello, fellow little hat. This man who's got the Cevallos, he must be Puerto Rican, I'm assuming, of some heritage, is opposing me from celebrating the fellow little hat holiday. Yes. They request that the court deny the request for replies and more time. Meanwhile, I asked the court to step in to regulate the filing habits. I agree. They submit the court does not need to read further. The defense counsel believe there's already too much back and forth the court does not need to hear. I agree. However, we have to respond. And, they have to respond. They have to protect their clients. And they say below is provided to create a record and correct the inaccurate statements. This idea about the consistent good faith efforts. They say, again, review the filings and see this isn't true. One thing the counsel hasn't done is to ensure efficiency throughout the litigation. Really true. Really true. And notice that real quick, this thing about the holidays. He says, I don't recall ever mentioning the holidays, but I will readily apologize if he did and I missed it. A true professional. Nico, yeah, we'll be covering that all tomorrow night. We got all kinds of stuff for tomorrow night. We got some really based stuff for tomorrow night too. It's going to be great. They point out that we haven't engaged in procedural violations. It is you, Mr. Benedict, who have repeatedly misfiled documents and missed deadlines. Moreover, his supposed professional courtesy began his denial of a request by the defense for an extension of time to respond to a complaint after being retained, something that is routinely granted. Yes. Remember, chat, being a faggot at the beginning and opposing shit like that looks bad to the court. Looks really bad to the court. And then the court gets involved and has to allow you a chance to respond. So that is how that works. That is how that works. Hold on here. What am I looking for? They say that, once again, you don't have a right to file cross motions. They say, once again, he's complaining about a deadline that they immediately extended when they were asked to extend it. And they also point out we don't have to respond to settlement overtures when the settlement demand is a non-starter, as Mr. Benedict's was. There's also nothing wrong with e-filing a document on Labor Day. As they point out, Benedict frequently files documents on the weekends, like his 2 letters on Saturday. It's just weird. He's working on the Sabbath, chat. When are these being filed on the Sabbath? Is he filing during, Shabbos? They claim his cross motions requested consolidation hearings, but the cross motions are already returnable at this time and place as the original motion. They say, the court can see defense counsel did not force piecemeal litigation. They did this with the numerous motions, misfilings, letter requests, and other filings. And they point out that you don't need more time. You have no right to submit. And they just keep pointing this point out here. And they do say, this request is confusing. The motions are submitted. But when plaintiff speaks of replies due, does he mean the defendants are entitled to serve replies? Remember, chat, you have motion, reply. You can phrase this with motion, opposition to the motion, reply from the plaintiff or the moving party. And now they're saying, do we get to then reply again? A surreply? It says, candidly, the defendants are not inclined to request surreplies, and they are not requesting them now. The court has more than enough to review, saying, we're good. We don't need more time. And if the plaintiff is going to request the court to strike untimely oppositions, then plaintiff's own late opposition to the motion should also be stricken, and the motion to dismiss is unopposed. Once again, this is, very good points. Very well argued here. And he says, I understand litigation can be sharp-elbowed at times, but the conclusory allegations about systemic violations and gamesmanship and other ad hominem attacks are really not necessary. You can make your points without using such loaded terms. Ultimately, whether or not you're granted leave to reply, all defendants ask is for the court to consider the filings and decide the anti-SLAPP stuff and give the priority to the anti-SLAPP motion. And that's it. I mean, once again, you could see class. This is class. Very well done. Like 10 out of 10. Would love to see this guy kick some ass again. So that is where we end up with the Stuttering John and Shuli and Karl thing. That's where we are now with that. So we're going to move on to Russell Greer here in a second, guys. And look, we got it done in an hour and a half. So Richard Gruber, it's good to see you, man. Starting off with the first post with an N. Once again, with the ever-timeless AK-47 drum magazine. Let's see, I forgot to ask, is that like a Korean or a Yugo one, or is it a Russian drum? I don't know who. I'm just curious. Is it a Chinese drum? Those are super cool. I think those are really expensive, too. Shredder S07. It's been a member for 15 months. Thank you for your support. It says, I double dog dare you. Thanks. Jim says Russell and John should do a podcast together. It would break the internet. Yes. Well, they both drool. They both drool, and at this point, both of them drool, and they're both uncontrolled now. Russell because of his Mobius syndrome, or Mobus, or whatever the fuck it is. I don't know. Is it the planet where Sonic and the Hedgehog live? Sonic and the Hedgehog. It's like Sig Hootie and the Blowfish. Sonic the Hedgehog lives. Or is it, I forget, I think that's what it's called, Mobius syndrome. And then Stuttering John just because he's a drooling alcoholic. That'd be so funny. Okay. Jay Wolfenstein for $5 says, can you sing Cherry Pie for Stacey Allen? It's a Dabbleverse thing. I'm good. Yes, Volty Bolty says, Russell Greer is a retard. He tried to sue a celebrity, Ariana Grande, for not accepting a date with him. Yeah, that's been his big thing. T.O. Hanks says his backstory is interesting. I mean, I guess it probably is at some point. Ask Kevin Brennan. Okay. And then Tim Pool is saying, I'm definitely not taking notes of Sean's allergies from my Sean torture room, which doesn't exist. Just fill it with spiders. That'll be enough to torture me. And then David, from Mickey Law Simple, thank you, David, for $4.99 says, here's $5 so you can buy a red crayon and color the rest. Well, thanks, David. JJ for $10 says, Suffer, Russell. Yes. Dakenstein says, my friend is a lawyer. Do you know him? Yes. All the lawyers know each other. Yes, I know your friend. I don't even know his name. Steve says, I heard Keith Urban and Keith Urban and Nicole Kidman are splitting up. Yes, they are. And we're going to go over that tomorrow. There is a really cool thing in their prenup that Keith Urban, because apparently Keith Urban likes to ride the White Stallion, or did, and I didn't know that about him. But apparently Keith Urban had like a fucking, cocaine thing. And for every year he stayed sober, he's entitled to $600,000. So now he's like, pay up, bitch. I want my 11 mil. It's like, wow. I'm like, whew. So interesting. We'll get into that tomorrow. But it's very funny. I'm going to make sure I have my list for tomorrow. And guys, if you guys are new and you haven't been here before, we do our live show every Thursday night at 9:30. And from, we're going to be talking about all kinds of stuff. Obviously, the steel toe update, YouTube bending its knee to Trump, some updates on the James Comey indictment, the Texas kind of refusing ABA accreditation for its bars, for its law schools, the Iowa teachers, very funny. And then the DOJ is suing LA County for only approving like a handful of concealed carry permits in the past 2 years, while thousands wait and then expire. So we're going to see finally some civil rights covering the Second Amendment. So it'll be good. Diddy will be getting sentenced on Friday. The government's asking for 11 years on all that shit for those freakouts or the freak offs. So we'll do that tomorrow night at 9:30. So let me see here. Sweet Bovine Incorporated says, good evening, Sean. Well, hello. By the way, Stuttering John also shoots Sharon Stone in the past, and the latter just settled. He's kind of a vexatious litigant. If I spelled that wrong, I apologize. Good enough. I understood what you're getting at too there. Vexatious litigant, yeah. I didn't know he sued Sharon Stone. Jesus. And then La Reddit, Silver member, says, John sued a radio station, and it was so bad they actually wrote new laws because of it. Do you mean the Sirius XM thing? No one has ever tried to do what he did. It was so stupid. Well, that happens. And then Stephen Cooper says, hashtag stub your toe. Stub the toe. I guess. Andrew Kelso says, I appreciate your coverage of the suit. Well, thank you. Another says, Sean miscalendared me. And then EDW Raptor says, damn, just got here and missed all the Rabbi Shmuley stuff. Oh, I'd say that guy's a fucking weirdo anyway, too. Felt like that shit on Twitter. That guy's a fucking weirdo. He's got to be a gay op. So. Her bodyguard hit him? Oh, well, it sounds like he deserved it. Mavka saying, YouTube hasn't even considered unbanning my account. Well, here's the thing. Remember, they said we're going to look into it. And then they said, well, we haven't decided what we're going to do yet. So that's their way of getting around it. They said, well, think about it. So Alex Jones is never coming back. So, are prenups still a thing? If you've got money and stuff and resources, yes, you should have a prenup. For Nicole Kidman and Keith Urban, yes, it makes sense they have a prenup. Stacey Allen says, I like this. Subscribe. Well, thank you. P-Dub says the bankruptcy court is no longer shielding InfoWars from the lawfare vultures. That's, once again, it's all about if you're not favored by the system, they will come after you. And honestly, a fitting point at this thing would be all those Sandy Hook families to be on an airplane in it. Fucking hit a mountain at this point for what they've done, Alex Jones. So, fuck them all. And I hope the FBI agent that cried like a little bitch is on there too. So, All right, moving on to Russell Greer, guys. Russell Greer. Oh no, Russell. Oh no, Greer. Russell Greer had a reckoning today. Ooh, buddy. Well, actually, it's yesterday, but Russell Greer had a reckoning. Can we fit the ATF in the overhead of that airplane? Sure. Fit them all in. Fit the CIA, the NSA, all of it. The NRO. Put all the glowies in there. Wait, Russell Greer. Guys, remember Russell Greer is suing Josh Moon and Lolcow LLC for contributory copyright infringement because of the two John Does, John Doe number 1 and John Doe number 2, the users Rustard and Mosif Jartelli, who posted links to the, one of them posted a link to the Google Drive where all Russell's gay shit was located, and then I think one of them posted actual stuff up on the website. So those are the parties that Russell Greer is going after. This is the memorandum, decision, and order. And here we go. And you guys want to see it's from the district judge. And here you go all the way down. You guys just want to know who it's signed by. It's signed by the magistrate judge, not the judge, but this is coming from the magistrate. And this magistrate and this judge work together, and they do very well. So what do they talk about here? Well, so here they are. They're collectively dealing with the first motion for sanctions against Russell Greer under Federal Rule 11. And then the second motion for sanctions against Russell Greer. And then the judge just referred this to the magistrate saying, I don't want this. You deal with it. It's like Command and Conquer Red Alert when the Russian guy's like, let's see how you handle this. So the first motion. The first motion is that that Russell Greer had made two materially false statements in court submissions. First, they took issue with the notice of supplemental authority in which he says Russell Greer kept saying that Matthew Hardin had violated the court's standard protective order by disclosing names and phone numbers of two witnesses that Russell Greer had disclosed, Russell's brother and his dad. Second, they took issue with Russell Greer's statement in his motion to bring venue back to Utah because remember, Null and Hardin had gotten it transferred to Florida because Russell Greer was too retarded to respond. Well, what happened? Russell said, well, I've got a guy named Steve Tawa. He's my teacher. He could testify on my behalf. And then later on, Russell Greer, okay, well, give us his information. So Russell looked it up, and then he's like, oh, well, he died several months before the motion. The defendants provided Greer with the opportunity to correct those statements within 21 days, but he didn't do so. So consequently, the first motion for sanctions was done. They didn't request specific sanctions, instead asking the court to determine appropriate sanctions. Now, so, however, at the hearing for this, Hardin requested either attorney's fees relating to the whole Steve Taylor thing and the protection order or terminating sanctions, meaning dismissal. The second motion, this is the video conference hearing on numerous motions, when Russell Greer filed his emergency motion to continue the hearing. He had been informed that he had attended a business meeting in rural Nevada in the city of Winnemucca. So Russell Greer could go in and say, I want to build a whorehouse. I like whore. And that's what he did. He wanted to go build his whorehouse and try to get eminent domain to steal a man's land so he could build a whorehouse. And it was on the same date and time as the hearing scheduled before the court. Greer attempted to reschedule the meeting, but was told it was not possible. That same day, the defendants responded and the court denied. And this is the one where Russell was sitting in the hallway and you could hear all the shit going on in the background as Russell had conducted a telephone conference in the fucking hallway of a governmental building. So through use of FOIA, we found out that Russell Greer was put on the notice months in advance. He already knew that he had to be in court. It wasn't scheduled emergency. That Russell Greer didn't ask for more dates, but there were other dates available. And that Russell Greer showed up solely for the purpose of pitching to the city the idea of eminent domain for him to build a whorehouse. Not that it was a business meeting, but it was him just petitioning the government. And remember, this is the one where the government was like, why did you even come here? I told you not to bother. And then the guy who owned the land Russell was trying to steal came in and was like, nobody fucking told me about this. What are you guys trying to do to my property? Because Russell's a fucking creep and a piece of shit. So, yes. And the farms looked it up and he was dead before Russell said he could testify. Yeah. Did I not say that? Okay, yeah. He died well before. Russell never knew. Russell didn't know. Russell had talked to this guy years ago, and it had been like 4 years since he talked to him. So Russell had no idea this guy was ready to testify or knew anything about him. Subsequently, there was discovered evidence indicating Greer knew about the meeting several weeks prior. Based upon that evidence uncovered the investigation, defendants contend that Greer manufactured the emergency. And accordingly, they served Greer with the second motion, gave him time to correct. After he failed to do so, they filed the second motion. In response, Greer asserts the scheduling issue was merely a goof-up. And given that change in stance, the defendants contend Greer has consistently revised his narrative since he was caught prevaricating. Prevaricating, that is a $20 word, chat. Mr. Hardin, thank you for using a good word there. Thus, dismissal is the minimum adequate form of relief. So, and they talk about Rule 11. And what do you do? Well, by presenting the court a pleading or other thing, when you sign it and file submit it or later advocate for it, the attorney or the pro se party certifies to the best of their knowledge, information and belief formed after an inquiry of reasonable under the circumstances, that you're saying this is true and accurate to my best of my knowledge, that the factual contentions have evidentiary support or if identified will likely have it after a reasonable opportunity for further investigation. And they say, if after notice and the opportunity to respond, the court determines that Rule 11 has been violated, the court can impose appropriate sanctions on any attorney, law firm, or party. And the purpose of Rule 11 is to ensure baseless filings and streamline the procedure. And the 10th Circuit, which is where Utah is, it says there's a two-step process when you're awarding sanctions. The first, you must find that the pleading violates Rule 11. The second step is to impose the appropriate sanction. You might say, well, that doesn't sound very hard, and it's not, but they're listing out how they're supposed to do it. This is building the appellate record. Under the first step, it also doesn't help that Russell's pro se. Under the first step, the court employs a standard of objective reasonableness. It's intended to eliminate any empty head but pure heart justification for patently frivolous arguments. You have to stop and think before making legal or factual contentions. And then the sanction must be limited to what suffices to deter repetition of by others similarly situated. And it's about making an example out of people. It's all about making an example. It's about setting the message. And he says, as for specific sanctions, the court may impose the extreme sanction of dismissal with prejudice, although that sanction is uncommon. To determine whether to impose that severe sanction, the court considers the non-exhaustive list of the factors: the degree of actual prejudice to the defendant caused by the misconduct, the amount of interference with the process, the culpability of the litigant, whether the court warned the litigant in advance the dismissal would be a likely sanction for noncompliance. He'd already been warned of that previously for not paying the monetary sanctions, and the efficacy of lesser sanctions. Well, Russell doesn't pay fucking money. He bitches and fucks around for months on end. The court can also do a sanction of directing payment for reasonable attorney's fees, but only if the sanction is imposed on motion and warranted for effective deterrence. When you're doing attorney's fees as a sanction, there's 4 factors. The reasonableness of the fees. So Matthew Hardin has to submit proposed fees. And as happened last time, he submitted a bill for $5,000 and the court gave him a haircut. which was entirely unreasonable, I think. The minimum amount required to deter misconduct, the offender's ability to pay, and other factors the court sees fit, such as their party's history, experience, and ability, severity, and the risk of chilling zealous advocacy. And they point out that Russell Greer must comply with Rule 11, and he can be subject to sanctions. However, when considering the sanctions, the court has sufficient discretion to take account of circumstances that arise in pro se situations. So based on the analysis, the court grants the first motion and denies the second motion, which is really fucking retarded to the court, but it's still a win, I guess. And they say that Russell Greer violated his Rule 11 filings of the protective order and the Mr. Taylor's status as a witness. And they impose an appropriate sanction against Russell. So they talk about the first things here. He violated Rule 11 by making statements indicating that Hardin violated the protective order. In response to the first motion, he admits that prior to the stating this, he never saw the protective order, and he had no idea that it required him to place a designation of the on that, saying it was meant to be protected, and that he was going off the blanket assumption that everything he produced was protected. And despite these admissions, despite saying all of that, Russell says that Hardin still violated it by disclosing the names and phone numbers because Hardin knew the information was confidential. And Greer asserts it was his opinion that he violated the protective order, and Rule 11 sanctions should not be imposed for expressing an opinion. Thus, in his own response, Greer demonstrates he failed to make an objectively reasonable inquiry about his statements before including them in his filings. And that's the thing, it's not an opinion when it's in your filing. Further, expressing an opinion or belief about a factual matter can amount to a Rule 11 violation when it does not have an evidentiary support. Yeah. That's why just saying, chat, you've heard people say, well, it's my opinion, and then they say something defamatory. Just saying it's your opinion doesn't insulate you. This is fucking legal myth bullshit. Oh, it's my opinion. That doesn't mean anything. You still can't run off at the mouth. And second, about Mr. Taylor being eager to testify. By Russell Greer's own admission, the last time he talked with him was in 2021, which is when Taylor agreed to be a witness. Greer admits he never spoke with Taylor again and could never reach to reconfirm his status as a witness. Russell contends when he made the representation, Taylor was eager. He was unaware that Taylor had died and was never given any notice of the death. And despite those assertions, he fails to show that he made any inquiry, let alone an objectively reasonable one, about Taylor's status as a witness in the 3 years before telling the court he was eager to testify. Russell, that means you fucking lied! Okay. I'm sure he's going to appeal this to the 10th Circuit. So, having concluded he violated Rule 11b, the court must determine the appropriate sanction. As demonstrated below, they declined to impose the dismissal with prejudice. Pussies! And instead, they ordered to pay Matthew Hardin's attorney's fees, an amount to be determined. So when they talk about all this, the court declines to impose the extreme sanction of dismissal. First, they failed to demonstrate how the relatively minor Rule 11 violations have hindered their ability to defend this case. At some point, this is the second time he's been sanctioned now. Although technically it's the third, because he got, first, he had the $1,000, and then he defied that, so the court sanctioned him $500 more. I'd argue that's sanction number 2. This is sanction number 3. You don't get to keep getting sanctions in a lawsuit. Eventually, you run out of road. So I hope, Hardin's able to hammer that at some point. As for any expenses, those expenses will be addressed through the court's award of attorney's fees. Russell never fucking pays. Russell never fucking pays this shit. It takes him forever. It took him, months and months and months to do it. And then he cried to the 10th Circuit and tried to appeal. Second, the violations did not meaningfully interfere with the process. I'd argue yes. Although the court expended some time and resources to address it, Greer's violations have not significantly affected the trajectory of this case. I don't know about that. Third, while the court acknowledges Greer's culpability for his violations, the court sees no evidence of bad faith underlying the violations. At some point, you were wanton and reckless, and we can infer your bad faith from your actions. He's refusing to do anything. Fourth, the court has not previously warned Russell that dismissal was a likely sanction for any Rule 11b violations. Such a lack of warning militates against the harsh sanction of dismissal. And then finally, the award of attorney's fees is sufficient to address the violations. It won't, though, because you guys are going to cut it down no matter what gets submitted. So Russell Greer has to pay an award of attorney's fees and an amount to be determined. So as indicated above, the reasonableness of the fees, the minimum amount required, Russell's ability to pay, can't pay shit anyway. So we'll see. They say in the first motion, nobody asked for an amount of attorney's fees, nor do they address the factors. Thus, the court is unable to determine the amount without further briefing. So Matthew Hardin's going to do that. So according to the court, will require the defendant to submit a brief no more than 10 pages within 14 days of this memorandum in order addressing both the appropriate amount of fees and the factors identified above. Greer then has 14 days to file a response in no more than 10 pages. So this is going to go into November because 28 days, we're at Halloween. The court denies a second motion. They point out, importantly, neither the second motion nor the supporting reply memorandum identify the provision of Rule B that defendants claim Greer violated. Instead, that Greer lied to the court when he manufactured the emergency. I mean, you're not like the candor before the court. I mean, like, this is kind of horseshit here. That's kind of horseshit. Like, I think this is bullshit. This is absolute fucking horseshit here. How this works. Once again, like it's the factual contentions of it's an emergency business meeting have evidentiary support. That the factual contentions are warranted on evidence or are reasonably based on a belief or a lack of information. So, like, what the fuck? Like, what is he supposed to do here? This is so fucking gay. This is so gay. I mean, it's good news. I mean, it's better than nothing. So. The court is left to assume the defense are relying upon Rule 11b3, which requires factual contentions to have evidentiary support. Yeah, I think so. And they're saying Greer did not violate it. Bullshit. Although the defendants have seized upon Greer's use of the word emergency, his motion only uses that word twice and does so specifically in connection with the request for court action. Notably, the only contentions they take with are that statements were formed about the meeting. The meeting was very oddly taking place at the same time as the court hearing, and he was unsuccessful in trying to reschedule the meeting. None of those statements violate Rule 11b3. And they say, first, Greer provided evidentiary support for the statements. He was notified about the meeting on May 1st, and his request to reschedule was unsuccessful. Second, it's undisputed. Greer's meeting was taking place at the same date and time, despite Greer's mischaracterization of that being odd. They say, although they have their own interpretation of the statements, the court cannot say those statements violated Rule 11b3. Bull fucking shit. So the court denies the second motion. So the first motion's granted. Russell has to pay reasonable attorney's fees. The second motion is recated. Denied. And Russell won't pay these until he gets threatened with more sanctions. Yeah. Just absolute horseshit. Absolute horseshit. So there you go. James Reed says, I can't believe they let them pay that long. Well, no, it's because Russell keeps on avoiding it. Russell keeps avoiding things. And he fights and jerks around. That's what happens here. So there we go. So Russell has to suffer. And hopefully it's a suffering in a full amount. And if I'm Harden, I would include in that motion with factors, this is now the third sanction that Russell Greer has incurred. He had the Rule 37 sanctions. He's now had the $1,000, he had the $1,000. He got the $500 delay, and now he's got this one. So that needs to be considered. It needs to be considered, and I think that's a great way to do it if I'm them. Yeah, Russell's going to drag it out another year. Yep. Which is absolute horseshit that he gets away with it. And, yeah. I'm never going to cover Rule 34, am I? Well. Oh, you guys are so funny. I mean, you guys are so cheeky. I mean, you guys want to cover Rule 34? Sure. Let's do Rule 34 right now. Why do you want to talk about producing electronically stored documents and tangible things or entering onto lands to inspect stuff? Why do you want to talk about this? I don't get it. No, I don't get it. No, Ag, the first one was the Rule 37. So that's what I was talking about. The first one was the Rule 37 stuff where he fucked around with Discovery. So it's just not Rule 34. It's because it's interesting. Yes. Wait, this doesn't involve a lactating Sonic. Yeah. Yes. This is relevant to the body cam footage. No. No, it's not. So there you go, guys. I mean, that's where we are. That's where we are with this. Russell Greer has to suffer. Hopefully it's something that he fucks around with and the court will threaten him again. But I think if I'm Matthew Harden in this motion, you should say, the court should be forced to tell him, quit fucking around. You could face dismissal at this point. So we'll see. I don't think it'll get that, but I think that's worth trying. It's worth trying. And Eagle Eric in Virginia, or Eagle Eric Va, says every Sean stream is an ASMR stream. I guess because I sniffle and stuff. I'm not sure. P-Dub says a quick model stream. Yeah, you know what? We'll play with the helicopter a little bit. We'll do some helicopter work tonight. We'll do some helicopter work. So we'll do that here in a second. You know what? Here, I'll set that up. I'll set that up right now. We might not get too far, but we'll do it. We'll do it here. Let's see. Live stream models. MH60 LDAP. And then what time's around? 10:40. We'll do 10:45. We'll hang around for about an hour or so, and then I'll have to pack it up. Alrighty, chat. There we go. We'll get this set here. Come on. Let's see here. Sorry, chat. I'm trying to find the thumbnail. All right. There we go. It's been created. Okay. So that is where we are. That is where we are with everything. I appreciate you guys sticking around. I know some of this stuff is not necessarily, like I said, I know you guys may not like this, but I like it. And kind of at the end of the day, I mean, we're going to cover the stuff I want to cover here. So I think it was worthwhile covering once again. I think the Stuttering John stuff is interesting from the, he's not a pro se litigant, but him and his attorney act like pro se litigants. I don't understand it. Why that's happening, but it just doesn't make much sense to me. But stay lobby. I like Stuttering John stuff. Well, thank you. Doom, like the Doom, says Stuttering John was on I'm a Celebrity, Get Me Out of Here. I'm sure that's what everybody on the show said when they hung out with him. Stuttering John was the host of the Tonight Show. I know he was like the announcer and everything, so, but I don't honestly, like, I only know that from the lawsuit. I never really paid it, like, I know like that I know the Dabbleverse people like comedy, but it's like I never watched Leno, like, so my parents never really watched it either. So gotta have these lawsuits to break up the chaos of the world. Well, that's the thing. Stuttering John's also great relief from, Charlie Kirk getting murdered and assassinated, and the fact that we kind of hang on the precipice of like right-wing death squads roaming the streets. It's a good thing to have Lemity. I'm just listing his credits because he always does. Oh, okay. Oh, he makes sure everybody knows it's just nonsense. Oh, okay. I thought you were just making sure I knew. It's like, I've heard some of it, but yeah. Let's see here. He's a hack! Well, actually, he never was. Playing with the helicopters, a new euphemism, yeah. Let's see here. Which hooker is Russell going to beg for sanctions money? Yeah, I don't know where Russell's going to come up with the money, but he's going to have to do a lot of work, man. He's going to have to give out a lot of handies. Stuttering John laughed about Charlie Kirk. Well, he can go fuck himself. Stuttering John can fuck himself. And then he said Jimmy Kimmel was guilty of a Nazi government. What? He was guilty of a Nazi government? I don't know. Right-wing death squads rise up. Yeah, well, I mean, we're almost there. Is that why Russell Greer is a male prostitute now? Well, I'm sure Russell does it for the love of the game. Russell Greer does it for the love of the game. Am I saying that Pinochet did nothing wrong? I mean, it worked really good for fucking Chile was pretty safe after the Generalissimo did his thing. It was pretty stable, throughout the 90s into the 2000s. Let's see here. Right-wing death squads sound kind of based. I mean, as much as we joke about it, guys, like I said, that picture I showed you of what happens in the Balkans, you're going to be the guy laying on the ground with a hole in your head. You're not going to be the guy standing over it with a smoking AK. As much as you could joke about it, that's the reality of it. So, yes, free helicopter rides. Yes, you can't run and you can't hide. All you'll get's a free helicopter ride. So, all right, chat. With that said, thank you guys for all being here. Tomorrow night, Thursday night show, we're going to do that 9:30. In the meantime, we're going to go play with the models for about an hour. And I will see you guys there. So remember, until next time, just because you did it does not mean you're guilty. Doesn't mean you're guilty. Stuttering John's guilty of a lot of things, like being a complete fucking retard. But thankfully for him, he can't go to jail for that yet. Good night, chat. I'll see you guys over on the model stream.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy?